Yeah, just one thing. In the beginning, just tell the participants that we are recording, right?
Yes.
So if there are any concerns or anything, they'll be free to leave.
Great. Good afternoon, good morning, good evening, everyone from wherever you're watching us from. Thank you for joining us for the third episode of the data privacy webinar series. I believe most of you My apologies for that. We seem to have been recording twice and thus came the echo. Thank you for joining us again this afternoon EAP. Our presenters today will be Debshi, Zahir, and Amit. They'll be taking us through what you need and how to start your compliance journey. And also there'll be a touch of the different departments, how the compliance for different departments, HR, marketing. So you ought to be keen. Also, the recording will be available so that you can share with your tips that you can see with the compliance is. And also you can see how the farm video can support you to start off your process. We won't take much of your time. We'd like to be done in the next 1 hour. So I will welcome Zahir to start off the webinar. Zahir, welcome.
Thank you, Virginia, and a very good afternoon to all of you. Good morning, good evening from wherever you're joining us. We're very excited to be with you once again. Right, I've got my screen working. So this is part 3 of the data privacy webinars. We've already done part 1 and part 2, and I hope that you were with us during that journey. Part 1 was about registration with the various authorities in our East African countries. In part 2, we talked about the key roles in data privacy, the data controller, the data processor, and what they do. And today, we're going to talk about how to actually start your compliance journey. And obviously, we'd love you to do it with BDO on board on your team. We've also got in literally 2.5, 3 weeks, our next webinar, which is going to go into more details on the data protection laws in East Africa. And then finally in November, before we break off for Christmas, we're going to have tips on avoiding complaints from regulatory bodies. Watch this space in the new year. We're going to have another lineup of a number of webinars, again, on data privacy. So we're committed to being with you, and we're hoping you're going to stick around and join us for the entire series of our webinars, and then also pick up the phone at some point and call us whenever you need any assistance. What is the agenda for today? We are going to go back and revisit the design principles in data privacy, and then we'll start with the gap assessment. What is the gap assessment? How do we do it at BDO when we're helping our clients? We'll look at the privacy framework and how you can implement those frameworks in your organizations. When you don't have an officer, how you can nominate a data processing officer, how to conduct a data inventory exercise. We will also look at policies and procedures in detail, and we'll give you examples of a lot of those. And then we'll go on to monitoring, and finally, we'll finish up with our services and a session for Q&A. So you're probably getting asked lots of questions. If you're the person who's responsible for data privacy, you've probably been asked, have you got a privacy framework? Is it working? Do you have a process in place to respond to personal data breaches? How do you handle data subject access requests? We're going to cover all of these questions and a lot more today. So let's go back to the basics. We looked at some design principles, and there was 8 of them. You've got 7 here within the GDRP. And let's quickly go back, because everything you do in data privacy has to be around these principles. So quickly, the first principle, proactive and preventive. You've got to be able to have assess, identify, manage, and prevent any data protection risks before the data breach. The second one is you have to have data protection as your default. So that's got to be your default setting. That's got to be your mindset. The organization's mindset has to be data protection first. Then you've got to have end-to-end security, from the point where personal data is captured in the organization, right up to the point where it's purged and removed from the organization's systems. The next principle is data minimization, where you're required to only collect, store, and use personal data that is relevant for your business and for your purposes and necessary. The next principle is user centricity. You've got to implement systems that with the individuals, with the people in mind whose data you're holding, and your systems have to be user-friendly. They have to be able to understand all of the jargon you're using. If you're asking them to click various buttons, they have to be simple and they have to be understandable, easily understandable. The next principle is transparency, where you've got to inform your customers what personal data is being collected from them and how you intend to use it. And the last overriding principle, obviously, is risk minimization, where you design and implement correct procedures and processes, and you've got the relevant ICT security measures when processing personal data with the objective of minimizing risks. You don't start on a data privacy program without the risk being the crucial element of it. I remember when I got married, my marriage curve looked a lot like this curve. So when I started data privacy, I was pretty fascinated that those who embark on data privacy go through the same sort of shock and awe. So just going back, you're on the one axis, you've got the activity, and on the other axis, you've got time. So the first thing that occurs to all of us when we learn about data privacy and the laws and everything else is just shock at what we've basically got ourselves into. It's a shock to the system, because it's not a small task, and the obligations are serious, the fines are serious, and this requires an organization-wide, enterprise-wide effort to actually get on top of things. So the next thing you then realize is, after the initial shock is, how little you actually know about data privacy, particularly when you start reading up, when you start getting awareness. And then I think you start to cool off as you get direct advice from people such as ourselves through specific events, like attending webinars, like reading articles, like being in touch with lawyers such as Amit, for example, who specialize on data privacy, and getting the guidance on what are the limits, what are the boundaries you cannot cross, and what is the data privacy path that you've got to traverse. And then the next thing is, obviously, you start talking to experts. How does this affect me? How does this affect my organization? Whether it's GDRP, whether it's our own local laws. If you're international, then it's going to be a number of laws. And finally, you've got a plan and you're ready to act. So you then come back and you hopefully talk to some experts such as ourselves about implementing your plan. And finally, you start, because data privacy is not a one-off thing. Data privacy is, just like everything else, like strategy and everything else, you're living it. Your organization, your people, once you start this program, okay, it basically, it's going to live with you, it's going to grow with you, it's going to be part of everything you do, your hiring, your product development, everything you do basically. So it's very long term. So let's talk about how we can assist and the kind of assessment we do initially to drive this. And here are some of the key things that we look at in terms of the data privacy framework. So starting at the left-hand side, going down, accountability. How is your organization demonstrating accountability in the area of data privacy? So in this particular area, we would look at all of your policies and procedures, and we would review all of these for demonstration that you are actually on top of the accountability area. The next is information held. Do you have a full understanding of the PII held across your organization, across all of your functions? And basically, this involves verification of personally identifiable information, the inventories which are to be undertaken and assessed for full coverage throughout the organization. The next area is lawfulness of processing. For each processing activity, does your organization have a justification and documentation of the lawful basis for processing of the PII? Then there's children's information, and this is going to be applicable to some organizations. If applicable, what are the collection procedures for parental and guardian consents for any information collected on children? Then you've got special categories of information. Does your organization collect and process any special categories of information? And has the correct treatment been undertaken to ensure that processing can be legally performed? Now, some of the special categories of information include data on race, ethnicity, any data which reveals your political opinions, any data which reveals your religious or philosophical beliefs. If you've got membership of trade unions, that's also special category. Your genetic data, your biometric data, data concerning your health, data concerning a person's sex life, and even concerning a person's sexual orientation. The next one is data privacy, transparency, the risk of transparency, and how is data privacy communicated to internal and external stakeholders by your organization. And the other thing we'd look at is your data subjects' rights, which is basically reviewing of your organization's internal policies and procedures and processes to address data subjects' rights. We all aware of their rights to access, their rights to rectification, their rights to erasure, their rights to restriction, data portability, and objection. Next, we would look at the role of the data protection officer. We would review your organization's justification to warrant having a DPO or not. This would include a review of the assessments which are undertaken, followed by a review around the governance and ownership of this position, including the tasks undertaken and how this compares with regulatory requirements. Next, we would look at the privacy risk assessment. And here our team, the BDO team, our expectation would be that privacy risks are considered by your organization and that they are documented accordingly. The privacy risk assessment basically is a review of your internal processes in place to demonstrate that these considerations are being assessed and addressed. Data processes, a review of your data processing agreement and the template that you're using and a review of the inventory of your data processes. And then next we'd look at data breaches, which is a review of your organization's data breach reporting process, how this operates, and how these are disseminated across the entity and acted upon. This would include identification, investigation, and reporting procedures relating to data breaches. And then we would also look at international data transfers. Has your organization taken into consideration the data privacy regulations affecting data transfer to overseas and international jurisdictions? And what safeguards have been put in place to ensure that this is done properly? And finally, awareness. We would review your organization's awareness of data privacy regulations, as well as internal data protection policies and procedures. And at this point, without stealing too much thunder from Dipshi, I'm going to hand over to my colleague. Dipshi.
Thank you. I will just take back the screen. Thank you. Let me know, Zahir, when you can see the screen properly.
Yes, you're on, Dipshi.
Thank you, Zahir. Thank you for this introduction and highlights on our gap analysis. I'm hoping to help participants here today flatten the curve a bit, or at least raise the point where they are. And we are starting now with how to implement a privacy framework across organizations. So I have in this slide simple organization of tasks classified into 3 main steps. So firstly, once we are agreeable on the privacy scope, which means, for instance, if we have an organization or a group of organizations, so where does it stop? Are we only implementing privacy for one system, for one process, for the organization, or for the group at large? This will enable us to define the scopes, and it is the questions that we need to ask in the first step. Second, once we are fixed on the scope, the next step will be to obtain management approval, which means, say you have key stakeholders involved on your project, so you need to have the budget and the approval to go forth with the privacy program framework project. Second, on the third part, we have to structure the privacy team. So we will talk about more details regarding the data protection officer in this project, in this PowerPoint presentation. But the key point here is, if you have a privacy team in the organization, it is better. We always recommend same for our clients. We have a data protection officer, the key person who will be leading the project, but it is better to have that person surrounded by the team, because that person alone will not be able to know, for instance, what is exactly happening in the HR department, what is happening in the IT department, and so on. So it's better to have a privacy team onboarded at the very start of the project. All right, and then the fourth step in this first phase is on the data inventory. I will be going through more details regarding the data inventory in my further slides, but just to give you a quick overview, the data inventory should form part of the first steps of building the privacy framework. Why? Because it is in this data inventory that we will be able to identify all types of personal data that we have in the organization. And once we are clear on that, we are clear on the different types of personal data, as Zahir mentioned, is it sensitive personal data? Is it data which have higher risk? It is only then that we'll be able to properly know which technical organizational measures should we implement to secure that data. All right. So once we have completed with the first phase, which is mainly gap analysis, data inventory, then we can move along to the next phase, which is developing actually the privacy framework and implementing same. So what do I mean by developing the privacy framework? So firstly, we need to set up a basic policies and procedures, standards and guidelines, which will cover the whole privacy framework. So again, this will be mapped, this will be designed based on the data inventory and the data that the organization holds. And in these policies and procedures itself, we'll be able to classify the different roles and responsibilities of various stakeholders in the framework. All right, so once we have developed these privacy policies and procedures, we cannot just keep them aside. We have to actually implement them, build a culture in the organization. We have to communicate these policies, these documents to stakeholders. And this is what we mean by implementing the framework. We have to build that culture. All right, this is the second phase. And then in the third phase, once we have completed with designing and implementing the framework, it's not enough, because of that, there are certain countries, certain jurisdictions mandate organizations to have a DPO. It is the role of the data protection officer to keep the ball rolling and to have continuous monitoring and oversight on the privacy framework. So say in year 1, you have completed your implementation phase, then in year 2, you have to continuously monitor whether you need more enhancements, whether you need to correct other gaps, etc. And this is what we do in the monitoring stage. Now I will move into more details. Firstly, we talk about the privacy officer. So who should be the data protection officer in your organization? It should be, I can give you a few guidelines. And firstly, that person should have an information on cybersecurity, technologies, and data security. That person needs to also have expertise in data protection laws and practices, but they don't necessarily need to be a solicitor, a lawyer, or an attorney. Expertise in data privacy, data protection laws is enough. Why? Because that person needs to actually promote the culture within the company. So these are the key characteristics, if I might say, of a data protection officer. And it is crucial to nominate one person who will be leading this project together with the privacy team at the start of the project. In the next slide, I will talk about the key roles of the data protection officer. So firstly, the data protection officer should be here to advise, to inform and advise. In your organization, if employees have any queries relating to data privacy, or they have requests and they don't know where to go, what to do, so the DPO is the first person that they will contact. Even when the DPO is in the process of implementing the privacy framework, he will need the onboarding, the collaboration of various employees in the organization. So this is why one of the key roles of that person, the DPO, is to always provide guidance and advice on how to go about privacy requests and so on. Thirdly, it is to monitor compliance, as we've said. So the DPO should be here to continuously monitor compliance and report to the highest level of senior management of the company, to be able to ensure that the company is on the right track when it comes to privacy compliance. And then fourthly, it is cooperation with supervisory authorities. So if tomorrow there's an investigation, there's any sort of request from various supervisory authorities, the DPO will be the main point of contact between the organization and those supervisory authorities. All right. Now that we are fixed on the DPO, the next point here is to talk about privacy inventory, personal data inventory. So we are still in the first phase, and these are the key points here that I want to highlight to you. It is crucial that we have a data inventory at the very beginning of the privacy framework. Now, what is the data inventory? You might have heard of the term record of processing activities, record of processing operations, and this is where we are going. So under the GDPR, it is mandatory to have that document, record of processing activities, and this is actually the data inventory. In that document, you will list down exactly what personal data you hold, what personal data you process in various departments of the organization. So here, the example here is you need to have one data inventory for the whole organization. And that organization has many departments. So alone, the DPO, it's a bit tricky for the DPO to fill the data inventory alone. That is why with the backup of the privacy team, which can comprise of different heads of departments or various departments processing personal data, you will be able to fill in the data inventory. Normally what we do is do it in form of a workshop. So in that workshop, we bring along all the heads of departments which process personal data. And in that workshop, we explain exactly what needs to be filled in the data inventory. Okay, so a few examples are what data we have. Where is the data coming from? Is it from data subjects? Is it from another company? And where does the data go? What are the recipients of personal data? Is it moving along different departments in our organization? Are we sending it to another organization? Are we sending it abroad? So all of these information needs to be documented in our data inventory. Why? Because it is the main document which will enable us to design the proper policies and procedures to be put in place, the proper contract templates to be put in place. For instance, say if we are in the data inventory, we know that we are sending data abroad to the US, to another country, in India. So then we know that we need to have cross-border agreements in place, for instance. Okay, so this is the very key reason why we need to start off with a data inventory. In the next slide, I will show you an example. Yeah, an example of a data inventory that we have filled in for a few departments. So finance will have information about maybe employees' payroll, HR, same, and then you will need to continue filling it for different departments. IT, customer service, and so on, we need to fill in the data inventory with all the details. And this is just a snapshot of the Excel sheet, but it is broader, longer, with more details, which can be included in that data inventory. All right. So once we are complete, now, once we are done with the data inventory, it will become easier then to move to the next phase, which is the drafting of policies and procedures. I will be explaining to you about a few main policies and procedures that we normally draft for our clients. So here is a snapshot of it. You have a privacy policy. So mainly the privacy policy will be the main reference document, which needs to be circulated with all employees. So if you have any query about how to go about a request for privacy, or you want to know what is data privacy, the answer should be found in the privacy policy itself. Secondly, we have records management policy. In that policy, you may list down the different types of records that you have, who is the record owner, what are the roles and responsibilities of those record owners, what is the roles and responsibilities of the DPO. All of that is listed in the records management policy. And together with that, a very important point that you should not miss is to have the records retention and disposal schedule. This is a very key area in data privacy compliance. You need to have proper retention periods set in your privacy framework. So this is how you can include it in a policy. So retention and disposal schedule in your records management policy. Other key policies and procedures are data breach response plan, data subject rights request policies and procedures, vendor management policy, and CCTV policy that is optional in case you have a CCTV policy, CCTV system in your workplace or not. So the data breach response plan will show you, should be able to tell you what to do in the event you have a breach. And similarly, for data subject rights requests, in case you have an access request tomorrow or a deletion request tomorrow, what should you do? The answer should be in your data subject rights request policies. Vendor management, here we mean data processors. So you might have a lot of third parties to whom you outsource certain services, your vendors. So how do you deal with those vendors? What measures do you put in place to manage and to have oversight on these vendors? So all of this is listed down in your vendor management policy. This is just 5, 6 examples of different types of policies we provide to clients. And there are more which can be tailor-made according to specific use, according to the specific needs of our clients. All right, so once we are done with policies, we have also a different set of documents, which is called notices. You might have noticed when you surf on the internet, when you visit websites, that you get pop-ups, cookie notices, website privacy notices, and you have to accept same. So this is actually the websites, the organizations telling people how we process your personal data, how we keep your personal data secure. And we do that via a privacy notice. While the privacy policy here is internal for us, for the organization, a privacy notice is a summary of that, but it is external facing for data subjects. And you may have different categories of data subjects. For instance, your customers can be one category of data subject. So you may have a specific privacy notice, which is directed to customers only. So it will become the customer privacy notice. If you want to have a separate privacy notice, which targets only website visitors, then you may have a separate website privacy notice. But that depends. You can also have one general privacy notice, which tries and encompasses everything for different types of data subjects that you deal with. And even for your job candidates or your employees, you should provide a privacy notice. And the aim behind is the transparency principle. We need to be transparent and tell the data subjects how we are processing their personal data. And we can do that via these documents, the notices, right? Next set of documents which accompany privacy policies and notices are procedures. So you may have logs, consent forms, undertakings to be signed by employees, by record owners, data sharing forms where, for instance, an agreement is too broad to have. You can have a simple data sharing acceptance form, data sharing decision form, and also regulatory filings, which forms part of the privacy framework. For instance, you have to register, you have to file with the Data Protection Commissioner, with the Data Protection Office on how you process personal data. And for instance, you may also fill in registration forms or transfer forms to these Data Protection Office. So now I have a few snapshots about procedures. This is just an example of different types of procedures which can accompany your main set of policies. So for instance, in the data privacy policy, you talk about consent. You need to respect consent of individuals when the legal basis here is consent. So behind, what should the data protection officer do? What should employees do? And this is detailed in procedures. So this is just an example, a flow chart of how you should go about when you receive a request, when you know that you have to fill in consent forms. So what do? You have to draft a consent form, you have to circulate it to everyone, you have to maintain a log. And if someone withdraws consent or says, no, I do not consent, then what should you do? You have to update your log, you have to see if the request can be approved or not, and then provide other alternatives. So all of that, it's very beneficial to organizations when it's detailed like this, in simple procedures with different case scenarios and guiding comments for you to know what to do when you have these situations. So this is one example of consent management. In the next slide, I have another example. That's for data breach. So it might seem it is actually very complicated to manage a data breach, but we try to make it as user-friendly as possible, the process, by documenting same in these different diagrams and graphics. So when you get a data breach, what should you do? Firstly, you identify the breach, you have to investigate and contain the breach, you have to see whether the risk level is high or it's low, whether you need to escalate same to the senior management. What should the DPO do? Does the DPO work in conjunction with the legal team and notify the regulatory authorities? Is it high risk? Do you need to notify the data subjects who have been affected by the breach? So all of that can be listed in those procedures, which will help the team, the organization, and guide them in the event we have a breach. And step 5 here is, once we are done with the breach, we have been able to manage it. So what are the lessons learned? What should we do for it not to happen again? We have to review our processes and so on. All of this is listed in the data breach response plan. And I also have a snapshot here for you of our risk scoring tool. So I've mentioned that how do you know whether the data breach which has occurred is high risk or it's low risk? So we have developed this tool, which is based on the ENISA guidelines, which you have a set of questions which you can answer, and it automatically gives you the rating. So if it's 1 or 2, then it's high, it's low risk. Then you don't need to actually notify the customers, the data subjects, for instance. But when it's high risk, which is more like 3, 4, and 5, then it's a matter of great concern and you need to take specific actions. All right, so this is examples of some key procedures and tools which will help you in your privacy program framework. Next. Now, once we are done with policies, procedures, and notices, there is one other set of documents which is very crucial and which needs to be implemented in organizations. These are agreements. If you have followed session 2 of this 5-part series webinar, my colleagues Amit and you've talked a lot about controller and processor, third parties, and the different types of contracts which need to be implemented between these parties. All right. So in your framework development, privacy framework implementation, you need to bear in mind that you also have to develop agreements. This can be in the form of standard templates, which we usually do, standard controller processor templates, and then in the appendix, you can have the appendix where you can modify, customize it for your different types of processors, cross-border processors, or third parties. So this is just a few examples of different types of agreements that you can have, but it's broader. I'm saying here controller processor agreement. It's in the case where the organization is the controller and you are sending data to another organization in the same country, and that other organization becomes your processor. So you need to have a controller and processor agreement in place. But in the event that you are sending it abroad to a third party outside of your country, then you can have cross-border processor agreements in place. Okay. And then there's data sharing agreements, so where you're sharing regularly with another third-party controller, for instance, banks or insurance companies or audit firms. Then you can use those data sharing clauses instead. Right? Good. Now that we are done with drafting, implementing all the various sorts of documents, we can now move on to the next phase, which is a bit about monitoring. So there are different ways of monitoring your privacy framework, and one of them is privacy audits. So the data protection officer should put in his agenda to carry out audits of the privacy framework at different intervals. The audits can be specific micro audits focusing on one subject at a time or one system at a time, or it can be a general audit for the whole organization. And we usually do that using our audit tool. And this is just a snapshot of the dashboard of the audit tool. So you need to go about all those privacy principles, which Zahir explained before, privacy by design principles, or in the gap assessment, all those areas were listed. So all of these areas should be audited. You should review. I didn't understand. Sorry, I'm really sorry about that. So you should review how it was designed. Say you have designed the policies and procedures at the beginning of the year, but during the year you have a lot of guidelines which are coming, laws which are amended. So those policies and procedures need to be reviewed again to incorporate those changes. So in the audit, it is a way for you to identify these corrective action points, where you need to review the design itself of the policies and procedures. And the second thing here is review the operating effectiveness of your framework. Say you have all those policies and procedures in place, but is it working correctly? Is everyone, all departments using the consent forms? Are privacy notices being shared with job candidates, for instance? So all of these questions you need to ask in the audit to see if whatever you have designed, all the policies and procedures in place are being used correctly. This is how the audit will enable the organization to further enhance the privacy framework. Okay, and the second way to monitor it is using metrics. Metrics here, I can give you an example. Say if you have, if you note down that there is around 10 data breaches in your organization every month, that's a risk. Then you say, okay, so I'm going to do more data breach awareness trainings. Then you start doing the data breach awareness training. Then you monitor whether after those data breach awareness trainings, whether there's a decrease in the number of breaches reported. And this is one metric. You monitor the number of data breach further to your trainings. And like that, you can develop different sets of metrics. In this slide, you will see a few examples of different types of metrics which can be developed. And this will enable you to measure the performance of the privacy framework. Are you investing resources, time in the correct place? Do you need to change your methodology and focus on other risk areas instead? How much are you deviating from the budget for data privacy? So this is how you develop those metrics. You can assign it to different departments to help you. And finally, you continue monitoring the system to keep it alive and growing. All right. So this is a bit about it. So I will now leave the floor to Zahir to continue with the presentation. Are you here, Zahir?
Yes, I am, Dipti. Very much so. Thank you very much. And I hope everybody found that useful today. Dipti, you can just continue sharing your screen right at the end.
Yes, sure.
Sure.
Is it coming through, Zahir?
Yes, it is. Thank you. Right. So how can we assist? As you've seen, data privacy is fairly complex. It requires organization-wide implementation. It requires organization-wide awareness, and it is a high-risk activity. We've seen in the last webinar where I talked about fines. I mean, the fines are they're just staggering. You're talking about 2.5% of turnover. So it can be a very, very large number. And in some jurisdictions, it's even higher. And in some jurisdictions, there are even criminal penalties. So we've talked about already all of these ways. We've taken you through the gap assessment. We've talked about data protection, remediation, and implementation, what a data protection audit is, our services to provide data protection officer services. And as you can see, we're very active on the training side in terms of training your data processing officers, in terms of data inventory, staff awareness, and so on and so forth. And also in terms of data privacy tools that are out there and frameworks that are out there. So please do contact us as and when you require any professional assistance. Next slide. Dipshi. Thank you. So here's the contact information, basically from our offices for East Africa, which is Kenya, Uganda, Tanzania, Rwanda, and Ethiopia. I am the contact person. You've got my mobile number there, which also has access to WhatsApp. So please make a note of that. And that is my email address. It is Zahir, Z-A-H-I-R .sheikh, S-H-E-I-K-H at bdo-ea.com. And in Mauritius, it's Sylvie Greco, and her address is Sylvie, S-Y-L-V-I-E .greco, G-R-E-C-O at bdo.mu. So we look forward to hearing from you. And I think we've still got a couple of minutes, so we'll take some questions and answers. We've still got 10 minutes to spare. Over to you, Virginia.
Good afternoon, team. Thank you, Zahir and Dipshi. I see Amit has joined us also, ready for the Q&A section. We have a few questions, and I'll start with Mary. Mary wanted to get a clarification to get the difference between the data processor and data controller. Also, as a stockbroker, we want to know if they're both data processor and controller. I believe this was addressed in part 2, but maybe a brief reminder on those. I'd also like to request the hands up, those who have put their hands up, to kindly post their questions in Q&A. It would be hard to have more than 5 people addressing the attendees at the same time. Over to you.
Thank you, Virginia. That was a fantastic webinar. Thank you, Zahir. Thank you, Dipshi. To answer your question, the data controller under Data Protection Act, the Kenya GDPR, the Uganda GDPR, and I believe it's also under the Rwanda GDPR, is someone who determines the means and purpose of processing personal data. And sometimes what happens is that there is confusion between the ordinary meaning of a processor and the data protection meaning of a processor. Let me explain that a little further. If, for example, you are collecting data and you are deciding that this is what I'm going to use this data for, you then become a controller, despite the fact that in the ordinary sense, you are processing that data in the ordinary dictionary definition sense. Okay. A processor strictly acts only on the instructions of the controller. So under the Data Protection Act, you've got to have an agreement between a data controller and a data processor, who then decide between themselves in which they are going to be data controllers and who's going to be data processors. And there has to be a clear-cut distinction between both. The reason for that is that, especially when it comes to liabilities, when it comes to data breach, when it comes to data breach notifications and timelines, there are very specific guidelines. So for example, a data controller has to notify the data, if in case of any breaches, and should you want to you have to report that breach within 72 hours of becoming aware of the breach. The data processor, on the other hand, has to report to the data controller, not to the data commissioner's office. So there are some very, very substantial differences, and which are very crucial when it comes to relationships. Now, let me give you an example specifically in terms of the stockbrokers. So stockbrokers are generally who act as intermediaries, if I'm not wrong. My apologies for any ignorance of that business, but I'm not a stockbroker. I don't know how it works. So for example, if you're an agent, you have to get instructions from somebody else. So you then essentially become a processor for that organization, right? But say you have employees, you do your own marketing for your own marketing purposes. In that case, you are a controller, right? So you're both a controller and a processor. The key to determining is where are my instructions coming from? Am I actually determining am I getting the instructions directly from somewhere else? And then I am going to determine what I'm going to do with this data. Yes, then you're a controller. If you're getting instructions from somewhere else, and you're acting on those instructions, then you're a processor, right? Does that answer your question?
I believe so, Amit. Thank you very much. Mary, if it's not clear enough, we've shared the contact details. You can reach out to us for more clarification. RISPA also would like to know the already emerging issues on data protection, specifically for Kenya.
The emerging issues specifically in data protection, I mean, data protection itself is emerging, right? That is very new. So this is a very broad question. I don't know where to start. The GDPR itself, believe me or not, it is just over 4 years old. So the GDPR is actually a toddler at the moment. But if I can give you what are the emerging issues is first and foremost, knowing where your data lies, right? Getting a data inventory done as what Deepsha said earlier, my colleague, that you need to know where your data is coming from and how it is moving. The data inventory, which was shared with you, the snapshot, is actually the genesis, the foundation, the beginning of your compliance. If you don't know where it's coming from and where it's heading, there is no way you're going to comply, right? It's like driving a car in the dark without lights and indicators. You know where you're going to head. So that is an emerging issue. Then after that, once you have the data inventory, you will then be able to see exactly what are the next steps to take. The other issues, the emerging issues, is I find a lot of organizations in my vast practice, the clients I come across in data protection, is that one of the biggest mistakes they're making at the moment is to register with the data commissioner's office, which is the compliance, before doing the data inventory. Now, one thing I need to tell the audience here is you must register with the data commissioner's office. It is mandatorily required, but you cannot become a data controller, the data processor before, without registration. But what is more important is that you should have correct information and it is not misleading in that form, right? So a lot of what is asked in that form, where data you are transferring your data to, for example, if you're using cloud services, if you're using data to transfer overseas, or what are the technical and organizational measures, you will not know without doing the inventory. So my recommendation, that is one of the emerging issues which I see on daily basis, is people registering before really giving it a deeper thought as to what they're doing with the data. So those are the two main areas at the moment I would look at.
All right, thank you so much, Amit. And I think besides having similar cases, some of the organizations will have unique issues emerging, and hence the need to involve experts in it. So we'll address in the next 7 minutes, we'll address one more question from Crispin Busire. It says, please address data protection in emergency situations. For instance, enrollment into food programs of for families. I believe in the restoration of arid and semi-arid areas or lands.
Yes, Crispin, thank you. Very valid question. I'm glad you asked. This has been a key issue, especially in recent years when the pandemic broke out, and governments, organizations required data in emergency purposes for trying to reduce COVID cases, which involve a lot of personal data. So under the GDPR, under the Kenya Data Protection Act, and also under the Uganda Data Protection Act, I believe there is a provision which says in cases of emergency, specifically in health situations, in emergency, natural disaster, calamity situations, there are exemptions by governments or relevant organizations who have got the authority to, for example, in public interest, right? They can process personal data in emergency situations, right? But of course, you have to demonstrate it is an emergency situation. And one of the lawful bases on which, for example, if I'm driving along a road highway and I get unconscious, I get involved in collision, you happen to pass by, you don't know who I am. You then take my wallet, you try to find my driving license or my ID card, and then you pass it on to a hospital, for example. You have a very valid reason, right? Forget about the emergency global government situations, but even in such emergency situations, your lawful basis for processing my data in an emergency situation like that is vital interest, right? So I mean, let not this some of these complicated data protection rules in any way stifle any emergency situation. So long as you can explain it, right? That's important.
Oh, thank you, Amit. It's interesting to hear some aspects of data privacy that we hardly ever think of, like if you get into contact with somebody's business card, if they don't give you authority to use it, you are actually in breach of the data privacy. So in emergency cases, we are allowed to. That brings us to the end of today's presentation. I see a few people who are requesting for the previous presentations. You have all these presentations available on our YouTube channel, Video in East Africa. I'll also post the link in the chat section. Don't miss out our next one, the part 4 of the data protection webinar. Zahir, if you could kindly remind me the date.
It's on the 19th of October.
Yes, 19th of, yes. Do not miss it. I see a few more hands raised. Kindly send your questions through the Q&A section. We are really trying to keep it to 1 hour so that we don't take up so much of the time, but your questions will be addressed by the team via the emails, and that we have you have submitted your registrations through. So thank you so much, and see you in October.
Bye, folks.